goal of trying to develop as an efficient practice as one can.
Right, and that makes a lot of sense. Before we go on to the next one, there you use the phrase bail assignment, and keep in mind some of the lawyers are going to know exactly what that is, but some of the very junior ones or the articling students may not. And from a business perspective, that could be something they need to know about. Could you explain what a bail assignment is?
Well, it's actually a very simple arrangement with the client, whereby when cash deposits are made at the bail office to meet the cash requirement that the court has imposed to secure release from custody, the client may assign that to counsel as part of the fees.
Yep.
And once the case is concluded in court, by whatever means concludes the case, trial, it may be a sentencing, withdrawal of charge, that check then would be returned to the lawyer.
Right.
And once you receive it, it's either going to be, at that point, deposited, crediting it to an account that's been rendered, or it will be put in trust pending the file being billed.
Right.
I think the process of receiving checks now on bail assignments seems to me to be a bit more efficient these days than it was for some period of time, but usually within a month, 6 weeks.
Let me ask you this sort of as a nuts and bolts thing, because that definitely isn't a major part of my own practice. But I do know that especially young lawyers, you know, you're the guy that answers the phone at 3 in the morning. Maybe you're the guy that does the bail hearing. Maybe you're the guy that actually does that. And actually, I don't know the answer to this question. Is there a risk to that, to being paid that way? Is there like, I recall something about Queen's Bench, I think they're called escheatment hearings or something like that. Is there any kind of a risk, or does that, or not so much, or you can explain to me, because I actually don't know?
Well, yes, there is a risk. If the client failed to appear, and a warrant was issued for his arrest, and counsel then made an application and was granted by the court to be removed from the record. Counsel is then no longer on the court record as counsel for this particular defendant, and his obligations are then over. But he would still have the assignment on the bail money, and all or some of that may be properly billable for fees incurred up to that point. Now, the file will probably, as a practical matter, go dormant at that stage because a warrant's been issued. If the warrant's executed, the client is rearrested, appears in docket court, bail then has to be dealt with. And when proceedings are concluded, because now a new lawyer has entered the picture, because the previous lawyer has been removed from the record, the assignment's still sitting there. The government will bring an application when the file is usually concluded in the Court of Queen's Bench for escheatment, which means that the government applies to take the bail money in plain English. People who may have an interest in those funds, for example, the defendant himself, the lawyer, because the assignment may not be for all of the bail funds. There may be a third party in the background who loaned the funds to the defendant who has an interest. They have a right to appear and make submissions with respect to the disposition of the funds. My experience over the years and what I have heard other lawyers say is that in the disposition of the escheatment application, judges are not particularly favorably disposed to having those funds, either all or in part, given to the lawyer.
Great.
He's the unsecured creditor.
Yes, yes, indeed. Yes, indeed.
Believe it or not,
Right.
even though he has the assignment.
That's right.
At least that's, I think, the general experience I've had. Others may have a different experience.
Yeah.
So to go back to your point about there being a risk
Right.
element, that's where the risk comes in.
Right.
So usually those arrangements are made between a lawyer and a client who have a good relationship, and maybe there's been a past relationship with the lawyer or his office that comes to bear in those circumstances. Sometimes cash bail requirements can be fairly high.
Right.
And if the client has mustered up those funds to secure release, there's then a period of time where it's problematic to raise an additional amount for legal fees.
Right.
So the practical way to deal with the problem is the bail assignment.
Yep.
And I have to say personally, my clients over the years have been excellent in terms of meeting their obligations, and it's been very satisfactory.
Good. Okay.
Yeah.
Well, that's fantastic, Clay. And that's actually, I appreciate it. It's good for me to know. That isn't something that comes up in my line of work at all. But I know that is, especially when you're just starting out, that could be, you're having cash flow problems, you're just starting up your practice, that could be really crucial. The next thing you want to talk about here, or the next thing we want to talk about here would be the role of the advocate in the criminal justice system. Could you tell me about that?
I think many young lawyers, again, looking at the first 1 to 3 years of practice, feel a great deal of tension and pulling at defense counsel from different constituencies in the criminal justice system. The courts are pulling in one direction because the judiciary is concerned about the allocation of scarce resources as efficiently as the courts can administer them. Crown prosecutors have their own requirements and their own obligations. Sometimes they will conflict with the defense counsel. The client himself or herself may be difficult with respect to the instructions that one is receiving. There's relationship with bail supervisors, police officers, parole boards, parole officers, correctional officers in prisons and remand centers, all pulling and creating sometimes conflict in the defense counsel, because the defense counsel is the one officer of the court who is in a very unique position. The Supreme Court of Canada has said more than once that prosecutors are ministers of justice, that they don't have a client. Their role is to ensure that all of the available evidence is properly placed before the court. And that doesn't mean Crown Counsel cannot advance a case with passion or asserting the Crown's case with vigor. However, there is a requirement that Crown Counsel do so in a balanced way, taking into account the rights of the accused and the imbalance between the power of the state vis-a-vis the individual. The court, of course, is concerned with ensuring that the trial process functions in a way that is efficient, that trial time is being properly used, and that counsel are prepared when they come to court, that cases are going to trial when scheduled, and that large gaps are not opening up in trial time that is then lost to the public, and who has, of course, an interest. But none of that is the interest of the defense counsel. The defense counsel has a client, and that is counsel's prime responsibility. The Code of Professional Conduct provides that the advocate is openly partisan, and that it is not the function of defense counsel to cooperate with the state in the prosecution against his client.
Right.
Now, there may be situations in which cooperating with the state may be appropriate,
Right.
because it's going to achieve something beneficial to the client. But that's the unique position of defense counsel. His or her function is not to simply accept what the court may desire if that is not in the best interests of the client, nor what Crown Counsel may want in a particular circumstance. And it's the role of the advocate to assert the position of the client very strongly